Climate change has been slightly slower developing, but there was a very important case in the Dutch courts. It began in 2015 when a group called Urgenda, which is a body campaigning for environmental rights, brought a case against the Dutch government complaining that they had failed to live up to their commitments under what was then the Kyoto Protocol governing emissions of climate gases. And that started off in the Hague court as a case about Dutch private law suing for breach of duties under Dutch law. But by the time it got to the Court of Appeal, it had really developed as a case under human rights law. And it was claimed that because of the potentially very serious consequences of climate change, it affected not only the right to a home and the enjoyment of the home, but also potentially the right to life. And that case proceeded to the Dutch Supreme Court, which early last year gave a decision upholding the complaint and saying and ordering the Dutch government to do more to bring its policies in line with its international commitments. Now, that hasn't sort of fed through to the UK, but it certainly has led to a number of cases being brought in other countries with attempts to sort of base complaints on the human rights. And that we had a big case actually in the Supreme Court relating to a proposed third runway at Heathrow, where there was an attempt by the claimants to bring in the Human Rights Act, but it was held that that didn't override the effect of our Climate Change Act, which is a very strong act governing climate change, climate emissions. But most recently, a case has been brought in the European Court of Human Rights by 6 young Portuguese children. It's called Youth for Justice, against the Portuguese government and others. And the group of 6 young people, ages ranging from 6, I think, to 20, have brought this case complaining that the failure, not only of the Portuguese government, but of 32 other countries which are members of the convention, their failure to bring in effective policies on climate change has resulted in potential threats to the life and well-being of these children. And now that has got to the stage that in November last year, the European Court of Human Rights decided that it should be given urgent treatment, and it sent cases to the 33 countries which are defendants, asking them for their responses to the complaints made in these proceedings. And so, I mean, what's interesting is how the experience of the Dutch case of bringing the human rights into the climate change context is now going to be carried back into the European court. So there one has a case of sort of cross-fertilization of the convention coming into domestic law and then being give it a renewed strength in the European court. And it'll be very interesting to see how that case progresses. But I've run out of time now. I think that does give you, I think, a very interesting case study of the interaction of international conventions and domestic law. I have no idea how that sort of case would play out in India, but there, of course, you tend to rely on constitutional rights, which was a slightly different thing. But we somehow adapted the Convention of Human Rights to give us the same sort of framework. So thank you all very much, and I wish you well for the rest of your conference. Thank you.
Thank you, Lord Conwith, for your enlightening lecture. We have with us Honorable we have with us Judge Michael Wilson. He is the judge of Supreme Court of Hawaii, USA. Sir, I'd like you to deliver your speech for or your lecture based on your topic. Sir, you're muted. Your Lordship, you're muted.
Thank you. And aloha and good evening from Hawaii. In Hawaii, we use aloha as a greeting that has the same meaning as namaste, in the sense that it recognizes the spirit that we're all blessed with. And that to some extent is the subject of my remarks. The aspect of human dignity and human spirit as it relates to the issue of nuclear fission energy. But let me in particular express my aloha to the esteemed members of this panel. Dr. Midha, thanks to you and the great Chandigarh University for the invitation to participate in this conference. And in particular, may I send my aloha to my honored friend and my teacher, Justice Swatantra Kumar, who's meant so much to me over the years as a justice of our Supreme Court, and also to Justice Benjamin and Lord Carnwath, Dr. Bava and Professor Akubo and Dr. Cohen. It's a privilege to be with you this evening. And Dr. Midha, thank you for making arrangements for me to present before Justice Benjamin. It's 11:30 p.m. in Hawaii, and even when I'm wide awake, it's difficult to measure up after a speech by Justice Antonio Benjamin or Lord Carnwath. And to this esteemed audience, I bid to you aloha, particularly to those under 40 years old, because you are facing the existential threat of global warming that will likely reach catastrophic proportions during your lifetime if present levels of greenhouse gas emissions persist. But during your lifetime, I hope you have the glorious opportunity to come visit us in Hawaii and perhaps visit me here at this beach house where I am privileged to be and enjoy sharing with my friends from India. Well, I'll share my screen here to move to the slides that we have. And let me say that this set of remarks is based on the proposition of a fool's errand. It's an accepted proposition, I would say, among this esteemed audience that greenhouse gas emissions must be reduced to protect Earth and its inhabitants from the existential threat posed by global warming. I confess to the psychological condition, a psychological condition known as climate anxiety. These slides are slides of Hawaii, and as you can see, and you probably have in your own way vicariously visited, I've lived my life in a place that in the collective human consciousness may be considered the ideal environment on Earth. And it's a place now recognized by scientists, along with India, who has become something of a partner with Hawaii, recognized as headed for the worst impacts of global warming. Energy production and its use is the largest source of global greenhouse gas emissions. Therefore, reducing the greenhouse gas produced by the energy sector is crucial to the survival of our world order, as well as these magnificent animal treasures of Hawaii that you see in this slide. It is inescapable that we must reorder our use of energy to reduce greenhouse gas emissions. My remarks offer for consideration the proposition that the solution to this global threat lies in our sense of humanity and the technology choices to remove greenhouse gas emissions from the atmosphere must reflect the moral imperative upon which a humane world and the rule of law is based. Technological choices based purely on raw profit and the feeding of our culture of consumption are unlikely to protect nature and prevent the human fear and suffering caused by this worldwide climate emergency. So what about nuclear fission energy? Should we rely upon it to reduce greenhouse gas emissions and prevent global warming? Well, nuclear energy is not a new concept. Humanity has truth tested its value. Nuclear fission energy incinerated 120,000 people in Hiroshima and Nagasaki when 2 bombs were dropped in 1945 during World War II. Since 1945, the power and promise of nuclear fission energy has been further demonstrated. $2 billion in cleanup costs were incurred in the state of Pennsylvania in the United States when the 3 Mile Island nuclear reactor melted in 1979. 300,000 people were evacuated from the Ukrainian city of Chernobyl when the nuclear fission reactor exploded in 1986 and dispersed radioactive material across Europe. Over 100,000 people were evacuated when the nuclear fission reactor exploded in Fukushima, Japan in 2001. The government of Japan estimated that the accident would cost at least $180 billion. Independent estimates suggest that the cost could be 3 times more. Other difficulties associated with the use of nuclear fission energy have arisen. Bombs have been lost from airplane crashes. As an example, a B-52 Stratofortress bomber broke up in midair, dropping its nuclear payload over North Carolina, state in the United States, in 1961. Nuclear waste has defied efforts for safe storage. As an example, a waste isolation pilot project in New Mexico designed to last 10,000 years leaked radiation twice in 2014, exposing employees and causing concern to the nearby community from the plutonium and other radiotoxins leaked into the air from the plant. Dr. Gregory Jaczko is a noted physicist and former chairman of the Nuclear Regulatory Commission of the United States, whose concern about the dangerous history of nuclear fission energy caused him to turn from an advocate of nuclear energy to a lifelong opponent. He concluded, after his service to the United States as the chairman, that the use of nuclear fission energy to solve climate change would be the work of a fool. Dr. Jaczko said, "From everything I've seen and experienced with this industry, I think that's a fool's errand. And I think it's going to fail the planet when it comes to dealing with climate change. This idea that nuclear power can solve this climate problem and be made free of accidents, those things just aren't true. We have to look no further than the actions we took to license 4 new reactors while I was chairman. I mean, obviously I didn't support those for reasons related to the Fukushima accident, but today of those 4 reactors, 2 of them have been canceled and the other 2 are years behind schedule and $10 billion over budget." consider from Dr. Jaczko's perspective the damage to human dignity that will be caused by resorting to large-scale nuclear fission to solve our climate emergency. To understand his reaction and those who follow his way of thinking, let me ask you, dear colleagues, to consider, in light of the history of the human use of nuclear fission energy, where we should put the reactors and their waste. Of course, it would not be placed in the sacred city of Pushkar in the presence of the sacred lotus lake of Lord Brahma. And we would not locate it in Varanasi in the presence of the Kashi Vishwanath temple of Lord Shiva. Nor would we consider putting a nuclear reactor or its nuclear waste in Amritsar in the presence of the Golden Sikh temple. To do so would be an insult to the humanity of hundreds of millions of people, a desecration of their relationship to God and nature. Yes, the moral precept underlying the environmental rule of law, the precept to protect the environment, is inconsistent with the insertion of nuclear fission energy plants and their radioactive waste into places where the human spirit shines and seeks renewal and enlightenment. May I respectfully suggest it is also inconsistent with the morality underlying the right to a clean and healthy environment and the duty to guarantee that right to a clean and healthy environment to future generations. It's inconsistent with that duty to place nuclear fission reactors and nuclear waste among the poor and the politically powerless. Some jurisdictions in our world have already used the rule of law to protect people and the earth from production of nuclear fission energy. It is against the law in Australia. It is against the law in New Zealand. We will not allow nuclear fission energy plants in Hawaii. Article 11, Section 8 of our Constitution states, no nuclear fission power plant shall be constructed or radioactive material disposed of in the state without the prior approval of a 2/3 vote in each house of the legislature. For those citizens of Earth who do not have the direct protection of a constitution that effectively bars nuclear fission energy, the rule of law nonetheless provides some opportunity to escape the threat of nuclear fission energy. Under the present robust framework of the environmental rule of law, a firestorm of legal action will likely erupt when the leaders of nations, such as India, together with private investors hungry to participate in a government-sponsored, no-risk, multi-billion-dollar nuclear enterprise, use climate change as an excuse to build nuclear fission reactors and insert nuclear waste poison into the earth. In conclusion, my dear friends and colleagues, may I gently suggest that a future in which we use nuclear fission energy to reduce our tragic present levels of carbon emissions will be an unnecessary surrender of our humanity and will require alteration of the environmental rule of law that presently protects people of our planet and presently protects Earth's magnificent, may I say, sacred biodiversity. And I conclude with my favorite sacred animal, the tiger, the animal that I had the blessing to find in India that is the vehicle of Ma Durga, goddess Durga. So to all of you, I say aloha and namaste. I am very privileged to be here this evening and again say aloha to you from Hawaii. Thank you very much for allowing me to make my remarks.
Thank you, Justice Michael, for edifying and acquainting us with the use of nuclear energy. Moving on, we have with us Professor Dr. Noriko Okubu. She's a professor in Graduate School of Law and of Law and Politics at the Socio-Legal University. Ma'am, if you may deliver your lecture, please. Ma'am, kindly unmute yourself. Doctor? Ma'am, if you can hear me.
Yes, sorry.
Thank you, ma'am.
Do you see my slides and hear my voice?
Yes, ma'am, you're audible and we can see the slides.
Thank you. Thank you for your kind introduction and good afternoon, all of you. It's my great honor to speak at this webinar. Thank you for inviting me to this session. Today, I would like to share with you the current situation of Japanese climate change litigation, focusing on the Kobe coal-fired power plant cases. Climate change litigation is booming and developing rapidly around the world, as shown by the Dutch agenda ruling, as Lord Camworth mentioned. However, there are many theoretical and institutional hurdles to overcome, such as non-justiciable doctrine, question of legal standing, and burden of proof, etc. In Japan, climate change litigation is more challenging to file than in other countries. That is because no environmental public interest litigation has been introduced in Japan. It is a totally different situation from India. The Kobe coal-fired power plant cases are one of the first climate change lawsuits in Japan. 4 lawsuits against the new coal-fired power plants are currently pending in Japan, while other developed countries, such as Germany, announced a plan to end or reduce coal-fired power generation. The Japanese government is still in the position that the high-efficient coal-fired power is one of the important measures against global warming. Following strong criticism both inside and outside Japan, the Japanese government has finally announced in last July to shut down 100 inefficient coal-fired power plants by 2030. Justice Wilson mentioned the Fukushima accident. After Fukushima, almost all nuclear power plants have been stopped and still rechecked. Therefore, the government will allow to construct and operate the new high-efficient coal-fired power plants. Civil society strongly criticizes that coal-fired power plants with more than 30 million kilowatt will continue to operate after 2030. That is the main reason why some citizen groups have filed lawsuits against the construction of new coal-fired power plants. This is a map of Japan, and Kobe is here where I live. Kobe is the 7th largest city in Japan with a population around 1.5 million. My house is located around here. And it is located around, about 30 kilometers west of Osaka. This is where the Kobe coal-fired power plant is constructed. The location is very close to residential area. The plant is planned and constructed by Kobelco Power Kobe Incorporated. It is Kobe Steel subsidiary. The new plant would have a total output of 1,300 megawatts and emit about 7 million tons of CO2. As Kobelco has operated already the plant with 1,400 megawatts on the same site, total emissions represent 1.3% of Japanese energy-originated CO2 emissions. 1,481 local residents, including my friend, applied for environmental conciliation against Kobelco in 2017. However, the original plan was not changed. The EIA procedure was completed in May 2018, and Kobelco started construction in October of the same year. There are 2 lawsuits against the new Kobe coal-fired power plant, civil and administrative one. First, on September 14, 2018, 31 families filed a civil lawsuit against Kobelco and Kansai Electric Power Corporation, which is power purchaser, seeking an injunction to prevent the construction and operation of the plant. Second, on November 19, 2018, 12 residents of Kobe City filed an administrative action against the government and asked the Osaka District Court to order the government to cancel the notice of finalization of an EIA of the plant. Interestingly, they also seek a declaratory judgment that the government has unlawfully failed to establish regulatory standards consistent with the Paris Agreement. Japanese legislation and case law has neither admitted environmental rights nor environmental public interest litigation. Therefore, first question of admissibility is what kind of plaintiff's right is affected and whether they have legal standing in the administrative case. It is a characteristic of Japanese environmental case law that the courts have recognized moral right to personality, jinkakken in Japanese, as legal basis for seeking an injunction in environmental cases. This development of Japanese case law is similar to that of the European Court of Human Rights. According to case law, moral rights consist of physical and mental rights to personality that also include right to live calmly. In the civil case, the plaintiffs claim 2 types of moral rights. First, their right to health will be infringed due to air pollution from the emission of harmful substances such as PM2.5. Second, they also insist the right to live in stable climate as a legal basis. As far as I know, some American cities, such as Lafayette, Colorado in the US, enacted the Climate Bill of Rights, recognizing the rights of humans and nature to a healthy climate. It is worth noting how the court interprets the scope of rights to personality in this case. In the severe case, the plaintiffs argue that the causal relationship between CO2 emissions from the Kobe coal-fired power plants and the adverse effects of climate change should be found based on the contribution of CO2 emissions. Interestingly, a similar claim has been made for the causal relationship in the Peruvian farmer versus RWE in Germany, which is a case for damages. Regarding the administrative case, the defendants, the Japanese government, argues that plaintiffs don't have standing. According to Article 9 of the Administrative Case Litigation Act, a person who has a legally protected interest has standing. However, according to case law, a legally protected interest must be concrete and individualistic and to be protected by legal provision that gives the basis for the administrative decision. Therefore, standing has not always been admitted for local residents adversely affected by the new facilities. In the Kobe case, however, local residents' health and their living environment could be more or less affected by emissions of harmful substances other than CO2. These effects are at least specific and sufficient to admit standing. The more important and critical issue is how intensively the court reviews the authority's obligation to take due account of environmental impact, including the CO2 emissions. The plaintiffs allege various flaws in the EIA procedure, especially not considering fuel types other than coal. It is arguable how effective climate change litigation is. Of course, litigation is not the only way to force governments to adopt more ambitious climate change policy. However, for example, the Sendai local government has strengthened the regulatory measure for the thermal power plants after filing the Sendai coal-fired power plants case. And there is also a case in which an operator abandons a new installation of a coal-fired power plant in Sendai. It shows that litigation could also contribute to promoting climate change policy. It should also be reiterated that climate change is now a human rights issue, and therefore, the rights-based approach should be taken. Unique and similar cases, such as the Kobe case, are now pending in various countries too. By sharing the various experience of each country, it would be possible to develop a new theory of causality, etc., from case law. This is a picture of Roko Mountain in Kobe, where I live. In Kobe, there are not only power plants, but also very beautiful national parks. Please visit Kobe after COVID-19 pandemic. Thank you for your attention.
Thank you for your enlightful lecture, Dr. Ukubo. We also have with us Honorable Dr. Ellie Cohen. Dr. Cohen is the CEO and founder of Ayla Water and Ecology Israel. So I welcome you. Kindly deliver your lecture, please.
Hi, everybody, and thank you for having me here, and the honor to be the last speaker. This esteemed audience, which I haven't seen for quite a while. Let me just try to open and just allow me to let's just open it over here. Just a minute. Okay. Well, I'm not going to talk about court and law because I don't know much about it, thank God. But I know quite a lot about, I think, about climate change and environment. And I know something else, that the interaction between the both is going to be quite intensive in the near future, because the problem of climate change is getting bigger and bigger, and this is the talk of the world today. And many asking, hope you see it right over here now, just a minute, and yeah. Okay. And my topic over here is climate change. Can we stop it? And actually, this is a question that many asking. I'm not really sure if it's possible to stop it. And I'll give you the answer just in the beginning. Yes, we can stop it. And we can even reverse it. We just do it right. Even now, when it starts kind of being a bit late, but it's never late. You know, in my background, my background is physics and thermodynamics, and we're talking about the diagram of phases, when you know that our environment and the physics law talking about many parameters influencing influencing our equilibrium stage where we are living and staying, and by changing some of these parameters, we create a situation where this diagram change is balance point, and then we can reach to a place where our life wouldn't be so sure, because we'll be in completely different stable conditions. And what are the reasons for this climate change phenomena that we're seeing? Is, of course, it's the global warming that's caused by intensive release of the heat and gases to the environment. And of course, there's a keep on destruction of green cover, which are actually the balancing power of nature to balance our environment. And we all know this. If you not, this is the famous triangle of the food, energy, and water, where food we can actually we replace it by consumption, and in order to create, to produce, to make this consumption, to produce the consumption, the need, and we keep on using energy and water, and it's actually spiral that never ends. We call it the Gordian knot, because it's actually, if you keep on producing, you keep on using energy, you keep on using water, and vice versa. And we actually need to break this vicious cycle over here. And it can be done. It can be done by, and the effect of this cycle is, we see it over here. It's climbing CO2 and carbon to the air, and the water pollution everywhere. Not only in the developing countries, you can see it also today in developed countries, etc. And it's getting, and the lack of fresh water and air pollution and etc. is climbing, and we need to stop it. And the only way to stop it is the only two ways actually to stop it is by two different means, two main means. One is to actually reduce consumption. It sounds easy, but this is the hardest things to apply actually, because this is the human nature. We want to consume. We were taught that we need to consume. This is the last years agenda of economy. This is actually of consumption. This is the wheels of the economies, consuming and producing. But we all know that we actually consuming too much more than we actually need. And by reducing the a little bit, even in 10, 20%, each one of us, each one in proportion to his lifestyle, of course, we can change the world, and it without changing our life quality and our life on progress at all. It's just a matter of awareness. We need to get into this awareness mode that we know that by doing it to ourselves first of all, and to our next generations, we can change it, and it can be done. It can be done, but it just needs a lot of awareness and integrity from each one of us in this case. And this takes us to the next stage, where we need to be more efficient in the way we use energy. Today, we're using energy in a very inefficient way. Many industries, for example, using energy in old-fashioned way, using technologies that have to be improved and changed according to the need of energy reduction. And by doing that, we can reduce the energy consumption in talking about many high percentage, and that will make a huge change in the overall release of carbon, etc., to the environment. But more than that, we need to change, and this is the more active way. We need to change the way we approach the solution to the environment, and to water treatment, for example. We need to use less energy and work more with the free energy that we get from nature. And I'm talking about over here about the nature-based technologies that this is our specialties, and we're doing for years. Is something that we implement. You can, as you see over here, in the heart of the city, system that can do the work for us with no energy, no chemicals, and on the other hand, they consume carbon from the air. And the more systems like that we have and implement in our urban, industrial, and the agricultural zone, we change the face of Earth. Actually, we're creating a new balance, a thermodynamic balance in the environment, without actually changing the final output, without compromising on the water quality or our lifestyle. It's on the contrary. If you think about systems like that, they're doing the same job like this one, then it's completely different story. We're having a solution that can work, and for us, be part of our lives, and they can do the same job and much better, because these systems treat and work on much more contaminants than this one is doing, and it's doing it in a very, very efficient way. And it can be in the small version or the big one, that like the one with the design for the city of Delhi. This is the north part of Delhi, for example. System that actually treat sewage as part of the landscape and treat hundreds of thousands of cubic meters per day as part of your parks. And not doing only this, it's also about water harvesting, recharging the aquifer. It's about reducing air pollution, and doing it by using no energy, and on the other way, consuming and absorbing carbon from the air. And it's also a social system that's being appreciated by the people, and people love to live nearby. And it can be done very easily. Very easily. It just need to, and we need to talk about a change of mindset over here. If we change the way we look at the environment around us and adapt this, go back to nature, but in its very active way, we can make the change work for us very fast. Because if we're consuming less energy but absorbing more carbon at the same time, the same area, for example, in the very populated city, it's a matter of few years till the new balance is being created. So this system can be look like this, and the water can be used on site without the need for extra energy to pipe it somewhere from here to there, etc. It just works for us as part of our life. And I know that it's easy to say, how to understand, because if you use to the old type technologies, which looks like the future, but we go back and look at the way nature's doing it, we can live with it, and we don't have to compromise on our lifestyle or on progress. We can do it at the same time. And I just have to, and something else I want to say about, for example, solar energy. We're all talking about the new future of solar energy, something that we have to be a bit careful when you talk about, because producing all this, for example, the solar panels, globally demand so much energy. And the amount of energy that we can get out of this system, even if we cover huge spaces, still not enough to supply all our energy need. So we'll still need the power plants, and also think about covering huge areas with the solar panels. What is this doing to the soil? It's not getting energy and the sun rays. And what about the reflection of the sun rays into the atmosphere? It's something that we have to keep in mind and think about the subsections of this approach to Earth, to the globally in general. And this solution of the one can be applied also to the rural areas, in the villages, etc., and can be applied everywhere on Earth in a very simple way by the people on site, harvesting rainwater, for example, recharging aquifers. It all can be done in a very simple and a fast way, but and to give us the water security and the air security that we need so much. And to summarize it, is when we're talking about environment management goals, we're talking about lowering carbon emission and better sewage treatment. This is about the environment, and it's possible. It's in our hands. And I hope this message is going through. I know that it's sometimes against the mainstream, but it's something that we need to keep in mind, and to know that there is a chance, there is a way to reverse climate change, at least to stop it, and it's in our hands. Thank you.
Thank you, Dr. Cohen. It was delightful to listen to you. We also have with us Honorable Justice Antonio Herman Benjamin, member of the National High Court of Brazil.
But as you know, it's very early in Brazil, and it's Sunday. So only my dear friend, Justice Kumar, to make me be this early. But of course, we all love India, and we are delighted to be here. Not just me, but also my colleague, Justice Michael Wilson, and my other colleague, Lord Robert Carnwath. My topic is human rights and the environment. Human rights is one of the main themes of this event, and I will discuss human rights from the perspective of the environment. And of course, this is a huge area, would require much more time. Unfortunately, I only have 12 minutes. So let me make sure that I do mark my time. I will begin without any longer introduction that the topic deserves by saying that there is no doubt anymore that environmental protection is part of the corpus of mainstream human rights law. Not long ago, 15 years ago, 10 years ago, this was still debatable. On the one hand, human rights law experts didn't want to be contaminated by environmental law. And on the other hand, environmental law experts didn't want to fit within the human rights agenda because it's obvious anthropocentric nature. Nowadays, we fully understand from both sides that there are benefits, and it is also a matter of necessity to fit environmental rights within the traditional corpus of human rights law. The question, or the first question to ask, is how can we articulate the protection of the environment within the human rights agenda? And basically, we follow the traditional approach of human rights law, dividing, and sometimes this division is arbitrary, but it's still useful, dividing rights between procedural rights and substantive rights. In the case of the environment, those two categories fit perfectly. For example, within the permit system, we have procedural rights that deal directly with the protection of the environment. For example, the right to a hearing, the right to participate within an environment impact statement, the right to receive proper information. So those are procedural rights. The second and more challenging category are substantive environmental rights, because here we are not dealing with matters of procedure or formality. We are facing the very substance of the values that compose environmental law. And it's within this context of substantive rights that we have the right to a healthy, clean, decent, ecologically balanced environment. The title varies from country to country, but it's basically a right to a clean and safe environment. And it's a right that on one hand is associated with health, and on the other side is associated with the protection of biodiversity. In respect to health, we talk about pollution and dealing with pollution. It's the topic of the previous presentation by my colleague, Eli Cohen. In respect to nature and biodiversity, the pathology here is not pollution, but it is degradation. And this goes all the way from deforestation, destruction of natural habitat, to the aesthetic aspects of the protection of nature, landscape, the beauty of nature. For judges, it's more complicated to deal with this substantive rights approach than with the procedural rights approach. On the substantive right technique, we judges have in fact to apply or try to guess what would be the public choices that are behind constitutional provisions, legislation enacted by Parliament, and regulations. It is more complicated because it's a value judgment. And as we all know, when we have value judgments or a space in which value judgments have to be made, reasonable people might see differently the same thing and come up with different or even opposite policy choices. For example, agriculture versus deforestation, or industrial growth versus air and water quality, or something that's so important to India and Brazil, housing versus pristine ecosystems. So the judges have a task to balance within the constitutional and legal framework those sometimes conflicting value judgments. There is a huge environmental jurisprudence that has evolved in the past 10, 15 years, including India. And I will mention a few cases in a minute. It's also important to realize that in addition to those two broad categories, procedural rights, substantive rights, we also systematize human rights and also environmental rights from another perspective. We say that they are either negative or positive rights. And I will give one example from the Constitution of India in a second of positive and negative rights directly expressed in the constitutional context. I am sure that my brother, Justice Michael Wilson, spoke about climate change. That's his favorite topic, although he is knowledgeable about many environmental topics. But we cannot avoid, in a conversation of 5 minutes with him, the topic of climate change. And why I'm mentioning climate change? Because human rights, environmental rights were already complex. And now we add a whole different level of complexity because it has to do with climate change. And as you know, from a legal perspective, we, in the context of climate change, have to deal with causes that often are not local. We have to do with consequences that often are not local or not just local, they are global in nature. And then we have to ask, what's the role of judges in dealing with this added complexity of climate change? Let me finish with two aspects, and then I will move to the Indian Constitution. Human rights, and the name already indicates it, is anthropocentric. Or let me rephrase it. It is originally anthropocentric. But we can envision within the human rights framework a broadening of the term human, because human doesn't mean only attributes, values, rights that are directly linked to us, humanity, but it also includes rights and values that are associated with the foundations of life, our lives and other forms of life. So it is possible to accommodate, not easy, but possible, to accommodate a non-anthropocentric view within the framework of human rights. My last point, and then I will move to the Constitution of India, has to do with another set of categories of human rights, and where exactly environmental rights would fit. We have already seen that environmental rights as human rights can be either procedural or substantive. We have already seen that they can be either negative or positive. Third, you are familiar with those three families of human rights: civil rights, political rights, and economic and social rights. Where does environmental rights fit within those three categories? There is agreement among the experts that the environmental rights would fit within the economic and social rights category. This creates some problems in terms of judicial enforcement of those rights. Judges, by tradition, have been applying those rights as civil and political against the state. But we do know that economic and social rights apply not just against the state, but they apply against private institutions and apply against citizens. So it is a set of rights or a category of rights that come together with duties. So the right holder is at the same time someone that possesses rights, but also duties and responsibilities. Let me move to the Constitution of India to explain, or at least to exemplify against the state in my last but we do know minute. In the Constitution of India, we have at least two articles that directly deal with the environment, and they serve as good examples of what I have just said. So in Article 48, the Constitution 48A, the Constitution states that, quote, the state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country, unquote. So here it is a human right that there is derived from a duty imposed into on the state. We could read this article in a different way. Every citizen has a right that the state protects, etc., etc., etc. Then, more directly, we have Article 51 that applies to citizens, 51 AG. And the Constitution states, and I quote, "It shall be duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures." And unquote. So the beauty of this provision is that the Constitution of India, as opposed to the Constitution of many countries, is not only concerned with human rights as such, but also with human duties in the context of human rights. And it attributes a duty to every citizen to protect the environment, not just the state, as in Article 48A. And in conclusion, this provision has one of the most beautiful phrasings in all constitutions of the world, because it's the only one, as far as I know, to allude to compassion for living creatures. It's not just to protect living creatures, it's to have compassion. It's probably one of the few, if not the only one, provision in a constitution that mandates love, but not just love among us human beings, but love towards living creature, towards nature. And this is absolutely extraordinary. But India is absolutely extraordinary. Many thanks.
Thank you, Honorable Justice Benjamin. It was a very edifying and didactic lecture, I would say. Moving on, I'm also given the responsibility to summarize the summary of this particular session. So we at Chandigarh University, we staunchly believe in the notion of partaking in anything that is based in the idea of instigating the much needed change that's required in the society. And I think that was visible in today's session as all of the dignitaries spoke. We started with Lord Conworth enlightening us with the interrelation between environmental law and human rights by giving us the example of the Dutch court case. After that, Justice Michael Wilson edified and acquainted us with the correct use of nuclear energy and whether nuclear fission is dependable or not. He emphasized on the saying that nuclear industry is fool's errands by giving examples of various nuclear disaster. After that, Dr. Noriko Okubu educated us on the Fukushima nuclear accident and other nuclear plants with respect to its impact on the environment. Dr. Ellie Cohen emphasized on whether climate change is reversible or not. Dr. Cohen talked about various solutions that are needed and implemented and need to be implemented immediately in order to reverse the climate change. Lastly, but most importantly, Honorable Justice Benjamin pointed out and talked about the difference between the different types under the heads of human rights and the category under which the environmental rights fit in. We're really obliged to have you all. Moving ahead, we will be taking up the questions from the audience for this session. The first question we have is from Ms. Nidhi Khak. I would request Ms. Nidhi Khak to kindly unmute herself and ask the question.
Good afternoon to all the Honorable Excellencies and distinguished presentees. My name is Nidhi. I'm a law student. It's a matter of absolute pride and honor to be able to be part of such a distinctive and informative line of thoughts. My question is addressed to Honorable Justice Antonia Herman Benjamin. Your Lordship, human rights are not foreign to any culture and they are intrinsic to all nations. How do you, as a judge, see your role as a promoter and protector of human rights? And more importantly, how do you ensure that the essence of human rights is not compromised because of religion, caste, customs, and race? Thank you.
Shall I respond, Razul?
Sure, sir. Absolutely.
Yeah, thank you. Well, thank you very much for the question. Of course, human rights is a very broad subject, and it involves all those three large categories that I mentioned: civil, political, economic, and social rights. And it's not, the evolution of human rights is not linear. You see countries that advance a lot and then they sort of collapse and then it comes back. In Latin America, for example, my region, we have had long periods of dictatorships, something that in India, since the republic was declared, you have been one, if not the most exuberant democracy in the world. A democracy with problems, because democracies are imperfect entities. But the importance of understanding human rights is that we have always to look forward, to make progress. Not, there is no room, or there should be no room for backsliding in terms of how you protect people, how you protect rights, how you protect people's beliefs, how you protect human dignity. It's one brick on the top of the other, and we have to resist any movement that intends to carve a hole somewhere in this wall that protect us and civilization, because once this hole is carved, once the wall is broken, we don't know what comes next.
Thank you, sir. Thank you.
Thank you, sir. The next question we have is from Miss Susanna A. George. Ma'am, I'd request you to unmute yourself and ask the question.
Good evening to all the excellencies. I am Susanna Augustine George, Faculty of Law at Chandigarh University. My question is directed towards Honorable Lordship, Lord Robert Carnwath. Your Lordship, you quoted various cases and incidences related to impact of climate change on human health, which direct towards the violation of their human rights in relation to right to healthy environment. Every human development is by and large against the environment. How can we create the balance or maintain the sustainability between human developmental requirements and environment?
Thank you very much for the question. I fear that as a lawyer and a judge, I'm probably not the best person to answer it, because the difficulty is that we can devise sort of laws and specific laws, and they have to have a sort of legal framework, but they don't necessarily always address these sort of social balance you're talking about. And of course, one of the things, the problems with human rights is they're about humans, not about the environment, about all the other things that make up the living environment. So there is a difficult balance to be drawn there. I think that at the end of the day, we just simply have to sort of work together to try and ensure that our laws and our practices bringing together all these different aspects, and that we don't have a sort of blinkered approach. So really, I think it's for your generation to try and build on what you've attempted to do, but there's a lot of work to be done. So sorry not to be able to give you a rather more specific answer.
No, sir. Thank you so much, sir.
Right. Thank you. So the next question we have is from Niket.
Yeah, good evening to all the dignitaries. My question is addressed to Honorable Professor Dr. Noriko Okubo, as she talked about people living near nuclear power plants. Professor, various scientific studies have shown an increased rate of cancer among people who live near nuclear power plants. Talking about a place, Chadugutta, which has India's oldest mines for the radioactive element, residents describe the degradation of their health and the environment is due to the ill effects of uranium. In your opinion, Professor, are developing countries like India ready to deal with these harmful effects of low-level radiations generated by nuclear power plants?
Thank you for your question. Also in Japan, there are so many discussions about it. And so I cannot give you a clear answer. However, the important thing to have this communication and transparency of information, I think.
Okay.
Thank you.
Thank you very much, ma'am.
Thank you, ma'am. The next question we have is from Sonia Grewal Mahal. Miss Sonia, yes.
A very good evening to everybody. It was indeed a great opportunity and honor to be a part of this prestigious international webinar and be able to listen to the valuable inputs of Honorable Lordships and esteemed dignitaries today. Honorable Mr. Justice Michael Wilson has enriched us with his pearls of wisdom on the important aspect of need of nuclear energy and the consequent environmental protection. His Lordship has very rightly emphasized that the sense of humanity and technological choices play a very significant role in this regard. I would like to invite the precious views of Honorable Mr. Justice Michael Wilson on the question, how will a check be exercised on the commercialization of nuclear energy vis-a-vis environmental protection by the authorities in relation to private and public sector? Thank you, sir.
Your Lordship, you're not audible. You're muted. Your Lordship, you're muted. Your Lordship.
All right.
Yes.
Yes. Thank you, Sonia, for the question. And I am very interested in the fact that you have focused on this idea of the relationship between private industry or the commercialization of nuclear energy and the law. And from the point of view of a judge, so let's discuss it from the point of view of a man or woman that's put into a position to interpret the law, where you see that commercialization is taking place for an industry that creates a potential hazard, there's a whole framework of laws that apply procedurally. Okay. And Justice Benjamin has rightly spoken of the importance of judges recognizing that there are limits to judicial decision-making. So a group of investors interested in an industry have to follow certain procedural regulations, but you're really driving towards the more substantive, if you will, human rights aspect of judicial decision-making when it comes to an industry that could be very damaging to the environment. And from that point of view, experts make a big difference. I think that it's important now to recognize in terms of industries that are very damaging, could be a pesticide industry, could be an environmental industry, whether there are alternatives. And we're fortunate that at this period in scientific history and evolution, as Dr. Cohen has said, in many ways, it isn't that complicated for a judge if a judge has to decide whether an industry like a nuclear industry is going to be able to proceed despite the kind of risk that could take place if, for example, if an EIS is done and there are alternatives to it. Now, the alternatives, I'll finish by talking about private industry. Alternatives generally are dismissed, and Dr. Cohen alluded to that, dismissed or minimized if they don't assist the financial welfare of large industry, financial industry players. So if you are looking at solar industries as a necessary industry 20 years ago, the other energy companies that are not in solar would do their best to inhibit it. And then there could end up with a lawsuit. And then it may be that a judge has to intervene. And if you have a younger generation, such as the people that are asking this wonderful question, that have made it clear they want good evidence. They want a judge that's going to pay attention not to the past, the status quo, how much success or problem there's been in the past, but being willing to look to the future with experts like Professor Cohen, experts who have become extremely focused through the international community, whether it's the IPCC, the Intergovernmental Panel for Climate Change, whether it's the Union of Concerned Scientists. So I would say the answer to your question is private industry has got to be able to show that it has, especially in an industry that's going to be particularly threatening or deleterious, it has to show that there isn't an alternative that would protect the community. And the judges have an obligation to be open-minded and allow for new information, new experts, because as Justice Benjamin said, we're all in the business now of trying to do something different. If we don't, this wonderful fabric we call the rule of law is going to shred, along with an Earth that heats up above 2 degrees.
Thank you, Your Lordship. Thank you.
Thank you, Your Lordship. The next question we have is from Shrikant Bhutani. Mr. Bhutani, please ask your question.
A very good evening to everyone. My question is to Professor Eli Cohen. Sir, it has been projected that by 2022, cities like Chennai, Delhi, and Hyderabad will have very low underground water to utilize and meet their respective demands. What steps do you suggest should be taken to address this issue so that clean drinking water can be provided to the citizens, as it is a fundamental right of the citizens and is also one of the sustainable development goals enlisted by United Nations?
Okay, I've just done it. Okay. Thank you for this in time, in place question. And yeah, and I'm privately dealing with it for 5 years already. And you know, India is lucky, many parts of it, to have a lot of rain. But think about it, you're losing something like 90% of the rain going down, the monsoon rain, you're losing it in many ways. Most of it goes to the sea, most of it get polluted and go and kill, kind of, if you say that way, the aquifers, if it's underground or lakes or rivers, and there is no proper management of this water. And if you think about this underground water, this is something that was created through the geological eras by water infiltrating into the ground. And it's not happening anymore because we actually destroy the green cover, and because we don't not harvesting water anymore the way we need to, we just get rid of it. And I did a calculation in Chennai, for example. You can recharge your aquifers, and it's a matter of a few years until you, wouldn't say fill up, but have enough water to supply the fresh water needed by the citizens of the city, and later on more for other purposes. And I'm not talking at all about treating sewage on site as part of your landscape, recharging the aquifer, and actually, and by changing the microclimate, by creating this, by introducing nature into your environment, you also reduce air pollution, etc. Which the bottom line is it needs more water for example, if you need to more air conditioning, you need more energy, you need more water to cool down the what's called the power stations, and it's a circle that never ends. So the way we treat, the way we approach the environment, and like beautifully said before, Justice Benjamin, about being about compassion towards nature. I think we need to add to it also giving respect to nature. And actually, if we respect nature, he respects us. Actually, we are getting compassion from nature up to now, but it's going to finish. And we need to do it in a right way, and it can be done for your question. Thank you.
Thank you so much.
Thank you, Dr. Cohen. Moving ahead, I would like to take the opportunity to invite Honorable Justice Swatantra Kumar to say a few words. Sir, you're muted.
Yeah. Can I request all of you to be visible on the screen, please, for just 5 minutes before they proceed further? I just would like to speak to you for 2 minutes. One is that, you know, I fully appreciate, Benjamin, that you gave me the liberty of waking you up on a Sunday on an early hour, and thank you for that. And one, I'm very grateful to you for that indulgence. Secondly, of course, Michael and Robert, both of you have been very kind and great of you to have really spoken so well. And Cohen, as well as Professor Nuguro, both have been really giving us great information. I would just like to say few things which I captured in the 4 sessions of this international webinar. The first is that I think the audience, and particularly the students, have learned in these 8-10 hours what they may not learn in one session or the one semester itself, and that too at a global level. So I need to thank everybody for that count. Some principles that have emerged out of it is, firstly, you must learn to change with the time. When the time changes, you change to achieve your goals, or you suffer the consequences. Secondly, during denying the right to livelihood is in fact denying the right to life. Destruction of nature or natural resources is definitely would result in degradation of environment and consequential diminishing of human life and worth of human life. Doctrine of intergenerational equity and doctrine of sustainable development and balancing are the sense for sustainable development. Judicial mind is influenced by mindset of environmental protection. They result in good judgments, and good judgments result in good mindset of the society. Well, the last thing I would certainly like to say is that we must make the education system strong, because they rightly said that if you want to improve a nation, improve the education system. And if you want to destroy a country, destroy the education system. So let's all work together. And I'm very happy to share with all of you that Chandigarh University takes the later path and improves the education system, dispensation of education, quality of education, and bringing the students to the upfront at the global level to achieve that the country does better tomorrow. Well, with these few comments which I got during this conference of international people, I once again thank you and wish all of you the best. And Benjamin, I'm sure you can sleep in the afternoon again. Let's proceed further towards the conclusion of the conference. Yeah. Go ahead, madam, please.
Thank you for your kind words, Your Lordship. As we conclude this 2-day webinar, I would like to invite Ms. Jannat Brar. She's our program head for international relations for the vote of thanks. Ma'am, please.
Good afternoon, everyone. This is Jannat Brar, Program Head, International Relations. On behalf of Chandigarh University, would like to propose vote of thanks to thank all the distinguished guests and speakers who blessed us with their presence by being a part of one of its kind international webinar on the theme Global Challenges of Modern Times. I would take this moment to thank the distinguished judge of Supreme Court of India, Honorable Mr. Justice A.M. Khanwilkar in absentia, and Honorable Justice Antonio Homan Benjamin, Member of National High Court of Brazil, Chair of the IUCN World Commission on Environmental Law, and Secretary General of the United Nations Programme, International Advisory Council for Environmental Justice for being the co-chair of this conference. I also thank Honorable Mr. Justice Swatantra Kumar, former Judge, Supreme Court of India and former Chairman, National Green Tribunal, New Delhi, and Chairman of the Academic Advisory Board, Chandigarh University, for providing the guidance for the event and for an address filled with extraordinary knowledge and wisdom. I feel deeply indebted to the distinguished speakers. Honorable Justice Michael Wilson, Judge Supreme Court of Hawaii, USA. Honorable Robert John Anderson Carworth, Lord Carnwath of Notting Hill, former British Supreme Court Judge. Honorable Professor Dr. Noriko Okubo, Professor, Graduate School of Law and Politics, Osaka University. Honorable Dr. Eli Cohen, CEO and founder, Ayaya Water and Ecology, Israel, for being there and sharing their profound wisdom and knowledge on various topics. I am sure that your inspirational advice will greatly motivate the bright minds of the future. Lastly, an event of this dimension, ladies and gentlemen, does not happen overnight. The wheels start rolling months in advance. We have been fortunate enough to be backed by a motivated and dedicated team, and I am deeply thankful to them. Lastly, I also thank the faculty members and student community from India and abroad for being active participants of the webinar. Thank you all.
Okay, before we part, I think we need to compliment Madam Brar also for her beautiful vote of thanks. And I wish everybody the best of time, best of future. And I'm very happy that the whole family, including the young Sandhu and Madam Brar and their good father and great father, Mr. Sandhu, the Honorable Chairman and the Chancellor of the Chandigarh University, for having put in so much of effort, for having really given me all the liberty to work with a free hand to bring this conference to the level which it has come. And I'm so happy to repeat that we have something like more than 1,200 attendees to attend directly and more than 28,000 people reaching it out this conference. So thanks to all of you. And once again, grateful. Greetings from India to all of you, please.
Thank you very much, sir. His Lordship, sir. Thanks to all dignitaries.